Hello everyone, welcome back to the Margdarshak. So as you people are aware that we are doing the polity series. In this we are already done with the 4-5 lectures and we are already done with the some chapters till the union and its territories. Today we are going towards the fundamental rights. And in last lecture we are also done with the citizenship. So today in the sequence of the articles we are to be moving toward the fundamental rights. So before starting this class, let me tell you one thing. Let me tell you about our mentorship program, that is Margdarshak mentorship program. So people, this Margdarshak mentorship program is for defense aspirant who are preparing for NDA, CDS, CAPF or FCAT. If you really wanted to prepare for this examination and if you are confused in your preparation that whether you are in right direction or not, what sources you should go with, what strategy and what preparation you should do, if you have these type of doubts what notes you should follow, then you can fill out the Google form that is provided in the description box. Accordingly we will schedule a call for you, and that mentorship call support will help you in clearing your doubts regarding your preparation. So that is all about Margdarshak platform. So let me tell you, this is free for everyone. So if you really wanted to join this mentorship program, then please feel free to fill the Google form. Okay, so without wasting any other time, let's move towards the fundamental rights. Okay, so fundamental rights. So let me tell you, this class is not for as in class on the such as in content creation. It is a class where we are focusing in the same sense that we focus in the offline classes. So I hope that you are following, you are sitting with a pen or paper in your hand. So without further let's move with the move further. So as you people are aware that we are done with the citizenship. Before that video we are also done with the union and territories, then the making of Indian constitution. So all we are done. Today we are moving toward the fundamental rights. So fundamental rights, why? Let me tell you, as a citizen of a country or a nation, you have some rights that give you liberty, that give you freedom, that give you everything that you require. There a nation provide you these rights for your against your duties, against any person, against any situation. These rights you can exercise to save your dignity, save your sovereignty, save your liberty, freedom, as well as other things. So these are the fundamental rights. Right are basically many types. That is human right, natural rights. Okay, but we are doing discussing the fundamental right. Fundamental right, these rights are basically the rights that are provided by a nation to its citizens as well as some foreigners. Okay, so these are the fundamental rights. So today we are going to discuss these fundamental rights, that what rights you have and how you can use these rights in your day-to-day life, in any situation that will help you in exercising your powers as a citizen of India, or an elector, or an active person of a country. So start with the fundamental rights. So in introduction you can say basically fundamental rights are a part of are part 3, are in the part 3 of the Constitution of India. Basically article 12 to 35 are under the fundamental rights. Okay, so these rights are basically inspired taken from the US Bill of Rights, inspired from the US Bill of Rights, Irish Constitution, okay, French Revolution. By basically these rights are from the US Bill of Rights. Okay, described as the Magna Carta of India. So basically if you are preparing for one day examination such as defense examination, then remember these things, that is Magna Carta of India is like fundamental rights are called Magna Carta of India. So you have to remember this because sometime they can directly ask you about Magna Carta of India. Okay, so basically objective was to establish political democracy, ensuring liberty, equality and fraternity. So basically justiciable rights है, enforceable through the courts, Supreme Court under Article 32 and for High Court under Article 226. We are just going with the context phase. We are just discussing the synopsis in this first slide. We will discuss everything in detail in the upcoming slide. So please feel free to sit comfortable in your bed or in your chair. We will discuss everything related to fundamental right. You don't have to be feared of anything. Okay, so basically features of fundamental rights. So these are guaranteed or justiciable, like we have discussed the preamble. So in preamble I told you that it is not justiciable, yani it don't have legal remedy. In certain circumstances, it for the preamble with other constitutional methods can be used as a judicial beacon. Okay, but here as in fundamental rights are the legal remedy available in the court, that is justice, they are justiciable. So in courts that you can go into the courts such as Supreme Court and High Court, they can uh, give the reads. Okay, uh, okay, not absolute hai, subject to reasonable restrictions. So basically these fundamental rights are not absolute, yani ki means in certain circumstances or in certain situations these fundamental rights can be curtailed for the betterment or for the sovereignty or for the independence of of our country. Okay, so basically some are negative in nature. So basically both we have both negative and positive natures of the fundamental rights. So basically in negative they prevent state, negative in nature, that is they prevent state from encroachment upon the liberties. Okay, such as Article 15, that is no discrimination, while in the positive sense we can say the state must act to ensure rights, such as Article 21, freely education. Okay, so there is a so this is the negative in nature and this is the positive in nature. So this is the difference between the positive in nature fundamentals rights that are positive in nature and negative in nature. Okay, so basically available against the state, Article 12 mentioned about the definition of state. What is state according to Article 12 we will discuss in the next slide. Okay, so state include basically government, legislature, local authorities. Okay, this is the definition you can remember, but if you want we will separately discuss about these articles in a next in last slide of this lecture, so that as a summary you can remember these things. Some also against private individuals, example Article 17, that is untouchability. Article 20, trafficking, human trafficking से related है. Suspension basically during emergency or except during emergency, these articles can be suspended except Article 20 and 21. The Article 20 and 21 can't be suspended during the emergency situations also. So basically fundamental rights, let's discuss about the Article 12 and 13 first. Okay, Article 12 and Article 13. So Article 12 give the definition of state. In this definition, the state include any government and well-defined legislature and a local authorities. Okay, local authority. It also include such as organizations such organizations that have an administrative machinery, such as LIC. Okay, a university is also a state. Okay, a company, an institution that have developed well defined institution. Okay, administrative system, that is the state, that can be called as a state under Article 12. Article 13, that is the so laws in derogation, yani ki laws that are not related to not they are not fulfilling the fundamental rights can be nil and void by the Supreme Court under the judicial activism. Okay, So judicial review, okay, so you can just remember judicial review. Okay, so these are the two starting articles of fundamental rights. Let's discuss about the fundamental rights. So basically there are seven type. Originally there was seven type of fundamental rights. First is right to equality under Article 14, 18, right to freedom and mentioned under Article 19 to 22, right against exploitation under Article 23, 24, right to freedom of religion Article 25 and 28, cultural and educational right 29 and 30, and right to constitutional amendment under Article 32. And the next article, that is seventh right, is the right to property under Article 31st. But due to the due to that contemporary circumstances, this Article 31 was removed by the 44th Constitutional Amendment in 1974, and it was made legal and constitutional. Legal, let me tell you, legal and constitutional right. Okay, and this was the question in multiple time. It was asked in UPSC examination, whether you are preparing for CDS, CAPF, UPSC, CSC or NDA. This was asked in every examination, that article that right to property is like what, a legal right, a constitutional right, neither legal nor constitutional, or legal and constitutional both. So this was the question asked. So what is your take in that? Please tell me in the comment section. So now we have currently have six of type of fundamental rights. We will discuss each and every articles, each and every right in the detail in next slides. Okay, so let's move toward the right to equality, that is under Article 14 to 18. So basically, right to equality, that is mentioned in Article 14 to 18. It says, Article 14 says equality before law and equal protection of law. Equality before law yani ki means that every individual is equal in front of the law. Okay, and equal protection law of law, yeah, means every person will be protected by the law in equal sense. No one is given any type of extra advantage or any type of preferences, any type of favoritism, nepotism is not in our constitution. We provide equality of law and equal protection of equality before law and equal protection of law. So basically it is basic part of our constitution. This is mentioned in article in under the Supreme Court judgment under Keswananda Bharti case, that was in 1973. Next is Article 15, that mention about the prohibition of discrimination based on the religion, race, caste, sex and place of birth. Okay, so it says that no one can be discriminated on the grounds of religion, race, caste, sex, place and birth. The related judgment is the Indira Sani case 1992, that is reservation kept at 50%. Okay, Article 15. Let me tell you, these judgments are crucial. You may find two direct question in your examination from the judgment. So please don't go in there is no need to go in depth. You just have to think. You just have to remember that what was this judgment related to. Okay, like what was Keswananda Bharti case related to? It is related to basic structure, okay, of constitution. Indira Sani is related to reservation kept at 50%. Okay, then after Article 16 says about the equality in public employment. It allows equality in the public employment, allows reservation for backward classes. Okay, basically equality in the public employment. Okay, allow करता है reservation such as for backward classes. Article 17 says about the abolition of untouchability. Okay, basically it is punishable under the protection of civil rights Act 1955. Then after Article 18, that is abolition of title except military academics. So just remember, Okay, कैसे कैसे, how we can remember these articles? So basically, what state first do? State first to make people confident. They first provide that we are making people equal in the eyes of law, in the eyes of judgment, eyes of courts, and in the eyes of our constitution. Okay, then after, okay, equality दे दी. Then after they said कि no, we have seen that there is some type of discrimination. Under Article 15, we are removing that discrimination. The discrimination was based on the religion, race, caste, sex, and place of birth. So we are going taking prohibiting the discrimination. Next, discrimination. Now discrimination is gone. Equality दे दी. Now they are saying कि we are also providing the equality in the employment. Okay, but we are also providing certain reservations for the backward classes. Okay, now people get the public employment, but there are certain issues that people still practice untouchability. So now government come with that Article 17. It says that we are abolishing the untouchability. If anyone caught with the practicing untouchability, and he will be punished under a protection of the Civil Rights Act 1955. Now the person have equality before law, that is equal in the eyes of constitution. Now then after he got he got a prohibition on the discrimination. Then after he got equality in the employment. Next he got abolition of untouchability. Now he had job, he have status. Now he wanted ki now I use the title, but government say no, title also need to discrimination. We are removing all type of discrimination. So under Article 18, government says, the constitution says, we are abolishing the titles except military titles or academics. Military titles such as major, colonel, squadron leader, group captain, these are military titles. Academic titles such as PhD, doctor, okay. So these are the academic titles. So I hope you remember these things in a good manner. Okay, next is right to freedom under Article 19 to 22. Under Article 19 there are 6 type of freedoms. First is Article 19(1). Article 19 clause 1 says about the speech and expression, freedom of speech and expression. Then after 19(2) says, 19 clause 2 says the assembly peaceful without arms, give right to assemble peacefully without arms. And then after Article 19(3) clause 3 give the right to making associations or union in a peaceful manner. Okay, then after Article 19 clause 4 give that right to movement, right to freely possess and movement. Okay, then after Article 19 clause 5 says about residence. Person have right to freedom of residence. He can live in any part of country, except there are some restrictions for some type of person such as prostitute from certain regions. Okay, then after profession and occupation, like everyone is free to take any type of profession or occupation that is legal in the sense, or that is not harming the sovereignty integrity of the nation. Okay, so these are the articles mentioned under the provisions mentioned in Article 19. Next, that is it also restrictions that are such as sovereignty, security, and public order and morality. So these are the restrictions. So next we are moving towards the next article that is very crucial as well as very important from our exam perspective, but that is the right in Article 20. Please read it carefully. Right of criminal cases. Okay, that is no ex post facto law, retroactive है ना, punishment not allowed, means any type of law, यानी someone committed crime on today, he will punished on the crime, on the laws based on today onward. He will not going to punish, like government say after 5 days ki we are making these laws, like you caught by the traffic police without helmet, and today is the fine of 5 10 100 sorry 100 rupees. But tomorrow government say we are amending the rules, now we are increasing the challan to 500 rupees. Now you will go to the court and you submit 100 rupees only. You say the court, because I have right under article 20 that no post facto law or law will be applicable. So that is how you are just paying 100 rupees. Okay, that is no double jeopardy. It means that no person is going to be punished twice for the same crime. Okay, that is no self incrimination, yani ki no person is no person is going to be obliged or pressurized for taking the crime on his head. Okay, so that is no self incrimination. Under article, next is under article 21, that is protection of life and liberty. Okay, very important right. You will find one question directly in your examination from this right in your every time. Okay, so basically extended meaning. Okay, right to dignity, livelihood, environment, shelter, health. It also include right to internet, right to sleep. Okay, so different type of articles it is mentioned under article 21. Basically it's protection of life and liberty, life and liberty. It provide dignified life. Okay, so important case, that is Menka Gandhi case 1978. Very important case. Please remember this case because it was asked multiple times in previous year papers and can be asked in your examination. It provide procedure must be just, fair and reasonable. Article 21A, that is right to education, under article for 6 to 14 years. Okay, under 86th Amendment Act 2000, Constitutional Amendment Act 2002. Article 22, that is right to arrest person. Okay, right of arrested person such as protection under arbitrary attacks. Okay, arrest. Okay, means anyone arrested under any arrested under the punitive crime, punitive grounds, that are preventive and punitive. Preventive is basically to prevent any type, if any type of misconduct, police or the enforcement agencies can arrest anyone on the preventive grounds. And next is punitive. If you committed crime, then the enforcement agencies and the police can arrest you, is going to arrest, that is punitive. Okay, so basically in this you have to be presented by the police in 24 hours, within 24 hours in front of magistrate. If they failed in doing so, then they have to free you from the any type of their they will have to free you. Okay, make you free. Okay, next is preventive detention, maximum 3 months होता है, expendable up to 12 months with the advisory board. Okay, so in punitive crime the person should be communicated with the what he have committed, but in preventive detention the cause is not binding to tell the person. Okay, next is article the right against the exploitation under article 23 and 24. Article 23 basically prohibit human trafficking, beggar and forced labor. Okay, exceptions including compulsory services for public purpose such as conscription, disaster relief, etc. So basically it prohibit करता है human trafficking and beggar and labor force को. under article 24 prohibit करता है child labor in hazardous industries below 14 years, है ना. under the act of child labor prohibition and regulation act 1986. Okay, so these are the rights against exploitation. Next is right to freedom of religion, that is mentioned under article 25 to 28. Article 25 says the freedom of conscience and right to profess, practice and propagate religion. Okay. Article 20 says the right to manage religious institution, that is under Article 27, 26. Next is under Article 27, that is no compulsion to pay taxes for promotion of religion. Article 28 says freedom from religious instruction in state funded school. Okay. uh, so basically the objective of the right to freedom of religion is to balance secularism with religious freedom. As I told you earlier that we have positive secularism. Okay, in that we are the state have made certain positive interpretation or positive intervention in the religious activities for the development. Okay, so these are the positive secularism. Okay. Next is the cultural and educational right under Article 29 and 30. Article 29 says about the right of minorities to conserve culture, language and script. Right of so basically, okay. Then after Article 20 says the right of minority to establish an administrative educational institution. So basically minorities are the cultural and linguistic. There are two type of minorities, cultural and linguistic. Linguistic minorities. Okay, remember this. So basically TMA Pi Foundation case 2002 clarify minority right in education. Okay, so these are the important articles that you have to remember. Next is Article 31, that was abolished. Okay, that was with the 44th Amendment Act 1978 it was abolished. Next is the right of constitutional remedy, that is mentioned in Article 32. It was an called heart and soul of the Constitution by B.R. Ambedkar. So basically, under Article 2, Article 32, under Article 32, Supreme Court can issue writs. Okay, and it is fundamental rights. Okay, that make the fundamental right enforceable in the courts. Okay, so under Article 32, as Supreme Court have the rights, under Article 226 High Court have right of writs. And let me tell you, the writ of High Court is larger than or bigger, have bigger rights under High Court compared to the Supreme Court. Okay, so basically direct access to Supreme Court for enforcement of fundamental rights. Right issued, there are five type of writs. Okay, first is habeas corpus, यानी release of unlawful detention, है ना. habeas corpus यानी to have the body. Okay, so mandamus यानी ना to perform the duty, यानी कि the judiciary, the court can direct or can reprimand a person to order and give him order to perform his duty. Prohibition यानी कि lower court stop from the exceeding jurisdiction, means higher courts can issue these prohibitions on the lower courts to tell them to stop from exceeding their jurisdiction. Next is certiorari, that is higher court quest order of lower court, that is certiorari. Okay, quo warranto यानी challenge legal occupation of public office. So basically quo warranto यानी क्या warrant. Okay, so you can remember क्या warrant. Okay, क्या warrant. So basically it challenges the illegal occupation of public office. Okay, next we are discussing about the restriction. There are certain restrictions on the fundamental rights. On that basis, the fundamental rights sometime they got suspended. So let's discuss the restrictions and the suspension. So basically restriction under Article 19, freedom subject to reasonable restrictions such as security, order, morality, sovereignty. Okay, religious freedom are restricted for public order and morality and health. Okay, Suspension during emergency, national emergency under Article 32. Article 19 automatically suspended. Okay. Presidential order can be suspended. Other rights except that Article 20 and 21. Okay. Case laws, that is the ADM Jabalpur versus Shivkant Shukla 1976. During emergency, even the right of life suspended. Later overruled in Puttaswamy case 2017. Puttaswamy case is related to under Article 21, that is right to privacy. Okay. Landmark Supreme Court judgment related to fundamental rights, that is Keswananda Bharti case 1973. It says the fundamental rights are subject to parliament amendment but not abrogation. Introduce basic structure doctrine. Menka Gandhi case 1978 under Article 21 expanded due to due procedural essential. So basically under Article 21, like in Menka Gandhi case was related to she wanted to go outside India, abroad India, for travel, and the courts were not permitting him, so that is why the Menka Gandhi judgment came. Supreme Court gave the Menka Gandhi judgment. In this, the court says that under Article 21, she has right to privacy, right to have dignified life, and she can go outside India. So going abroad is mentioned in Article 21, and freedom to move in India is mentioned in Article 19. Okay. So Indira Sani case 1992 basically related to reservation policy upheld, kept at 50%. Puttaswamy case 1970 related to privacy under Article 21. Navjot Singh Johar case 2018, decriminalization homosexuality. Okay. और सायरा बानू केस 2017, ट्रिपल तलाक अनकॉन्स्टिट्यूशनल. Okay. Next, some critical evaluation, that is fundamental right protects individual liberty but also ensure collective harmony, constitutionality, consistently evolving via judicial interpretation. Criticism देखा जाए तो suspension during emergency undermines liberty, preventive detention misused. Okay, it can be used for political purpose. Okay. Then after judicial overreach versus activism debate, that on what how we can decide that the court is using the judiciary for judicial activism, not overreaching their powers or breaching on the other parts, that is legislature and executive. Okay. Still fundamental bedrock of the Indian democracy. So we are done with the Article 32. There are certain articles such as Article 33, Article 34 and Article 35. So I forgot to add these articles in this PDF. Okay, I will let you know these articles now. Okay. So I hope, so let me tell you, please take a notebook and note down these articles. I will provide a PDF in our Telegram channel, but I will suggest you please write down these articles. That will help you. Like you will remember these articles if you write by your hand only. So basically Article 33 says that the Parliament has power, to restrict these fundamental rights for the security forces, security personals. Okay. Article 34 says there restrictions on the fundamental rights during the martial law. Okay. Article 35 says that legislation to give effect to some of the provision of the fundamental right. It gives some legislation for the legislative provisions to give effect to some provisions of the fundamental right, that is mentioned in Article 35. Okay. So these are the articles. We have discussed everything related to fundamental right. I hope you like this video, and I suggest you please share this video with your friends. I know I am not regular these days, but I will try that from next video I will be doing these videos on alternative days. That will helpful for you as well as for me. Okay. But due to some professional commitment, I was not able to be regular in these days, but now I will try to upload 3 to 4 videos per week, and this is how we can complete our syllabus of polity in next couple of weeks. Okay, so that is my strategy. I hope you are enjoying this series and learning something from this series. Thank you. Have a nice day. Jai Hind.